led the way with a separate 16 over 3 days. Well, 18, 9 in the hospital and 9 in the grave. So we have to just try and put this thing together, and police is keeping to make deployments, otherwise additional deployments, additional training, but sense the urgency of getting this bill through the House, because all the incidents were, I think, in this case, shootings. But thank everybody for work. Now we'll just have to keep at it and get it out on time. Not time to matter. Ms. Grant, I think we can go straight to the reading now for 35. I think we had finished 34.
Thank you, Chair. Good morning, everyone. Can you please just confirm that you're seeing my screen?
Yes, Ms. Grant, we're seeing your screen.
All right, thank you. So we had left off at 35.2, failing to declare firearms or ammunition or making false statement in declaration. On summary conviction before a parish court, a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years. 36.2, failure to comply with procedure in respect of declared firearms or ammunition. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 38.2, manufacture of firearm or ammunition other than under and in accordance with firearm manufacturer's license. On conviction before a circuit court, imprisonment for life. (39.2), testing, etc., without authorization. 1, on summary conviction before a parish court, imprisonment for such term of not less than 5 years as the court considers appropriate. 2, on conviction before a circuit court, imprisonment for life or for such other term of not less than 7 years as the court considers appropriate.
The first item, not less than 5 years in the parish court. In the parish court, the maximum is 5 years. This would be like mandatory 5 years. Mr. Ritter. Not less than 5 years, so it can be less than 5 years. A mandatory minimum in the parish court. Okay. All right. Sorry. Go ahead, Ms. Grant.
(42), illicit dealing. 1, on conviction before a circuit court, imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole. Upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole. 2, on conviction before a circuit court in the case of possession of 2 or more firearms or any other conventional arms or 20 or more rounds of ammunition. Imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which, I'm sorry, I seem to have skipped the page. Right. Imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole upon sentencing a person convicted for a felony Under this subsection, the court shall specify a term of imprisonment of not less than 20 years that the person shall serve before being eligible for parole. 40 subsection 5, allowing premises, etc., to be used for trafficking, etc. On conviction on indictment before a circuit court, a fine or imprisonment for life, and notwithstanding provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of not less than 15 years that the person shall serve before being eligible for parole. 40 subsection 7, on conviction before a circuit court, a fine or imprisonment for a term not exceeding 15 years.
Sorry, good morning. May I inquire in relation to the previous 40 subsection 5?
Yeah, go ahead.
Yes. If you have it, this is in respect to allowing premises to be used for trafficking. If the sentence is written in this particular fashion that says, on conviction before a circuit court, a fine or imprisonment for life, can I be guided? The court then views that as being that their first option is imposing a fine, if you state it in that way. What is it that you're trying to achieve, Minister?
Yes, wait, that doesn't.
And this is where a person with intention is allowing his premises to be used for the trafficking of firearms.
The fine not supposed to be in there. How did that get in?
Because I think wherever a court sees a fine that is going to be given, and then you'd have to then show probably aggravated circumstances that would then cause them to go to the second aspect of sentencing, which is the term of imprisonment. But if the person who is doing the trafficking, I think that person gets a minimum period, well, life or minimum of 15 years or 20 years, as the case may be, whatever we ultimately come down to.
A big gap. Go ahead.
So members think just to point out, the formulation there doesn't necessarily mean that the fine will be the first option for the court. It's just saying that the court has the option to either sentence or give a sentence that is a fine or a term of imprisonment.
Yes, I appreciate that, but just when I hear judges imposing or going through their sentencing of matters, you tend to find that once there is reference to a fine, that is what they will start. They may start with that, and unless there's aggravated circumstances. But we are speaking about somebody who is obviously with intention, because there must be mens rea involved, allowing their premises to be used for arms trafficking, and you are giving that as an option.
Structure this will look right. Because fine instead of a life imprisonment, that's a wide, not consistent, and the circuit court. I think you have to define that you can put a bandwidth for the sentencing, but not a fine. Not sure how this came up in the mix here. Just reading it. Thank you, Senator.
Welcome, Minister.
Yeah. Even anti-gang. I've seen anti-gang it and be approved for this. This comes under the, because a lot of these things are coming from the old schedule. And they could mix up in there. And this is not workable like this. We have to.
Okay, Minister.
Square bracket that. Look at it again. All right, thank you. Thank you, Senator. Ms. Grant, you can go on. We'll make a note of that because this is inconsistent. All right.
Chair, your audio is a little low. I don't know if anybody else is
All right.
having this.
Sorry. All right. I'm saying this doesn't look, um, it doesn't look consistent. It's a little bit odd. So I've asked them to make a note of it, and we'll look back at the policy guidelines and discuss with you. A fine without any limits and imprisonment for life will seem to match in for trafficking. Trafficking in the first part of it is life imprisonment straight. And I'd expect it to be the same here, to be consistent. So we'll make a note of that. Ms. Grantor can go on. You hear me a bit better now?
Yes, thank you.
Senator Golding, you hear me now? Okay, you're having a difficulty hearing anybody at all.
I'm hearing no, Chair. Thank you.
Okay, thank you. Good. All right. Senator Singh. Okay, proceed, Ms. Grant.
40 subsection 12. Restriction on purchase, acquisition, sale, or transfer, disposal of firearms and ammunition without the requisite authorization. On conviction before a circuit court, a fine or imprisonment for a term not exceeding 15 years. 41, subsection 2, restriction on transfer of firearm or ammunition in contravention of any terms or conditions imposed by the authority. On summary conviction before a parish court, a fine not exceeding $1 million or imprisonment for a term not exceeding 1 year. 42, subsection 3, accepting delivery of firearm or ammunition contrary to section 42(1) or failing to record particulars as required by section 42(2). 1, on summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 2, on conviction before a circuit court, a fine or imprisonment for a term not exceeding 10 years. 43, subsection 2, sale, testing, modification, or proofing of firearm or ammunition contrary to requirements for holders of gunsmith's license. On summary conviction before A, a parish court, imprisonment for a term of not less than 5 years. B, a circuit court, imprisonment for a term of not less than 15 years. 40, subsection 12.
God raised this with you, Ms. Grant, on an earlier occasion. Is it this 45(2)? Is it dealing with a situation that you may have a licensed firearm and your license may have been expired? Is that what 45(2) is?
I think more Mr. Richard here. 45, yeah, that's where we are now, 45.
Somebody from MNS would like to take that.
No, we just read 45, 43, 45, 201, dealing with unauthorized possession of firearm or ammunition. The question is this related to the person who may not have licensed firearm because it's not authorized, or you gave it to somebody who doesn't have a license? This look harsh for the licensed firearm holder.
Having a difficulty hearing the DPM.
I'm saying this 145 to a little bit. Is to clarify whether it is it a licensed firearm holder who has not licensed his firearm, or has given it to someone to hold who doesn't have a license or a permit. This would be harsh for the licensed firearm holder. That's the whole separation here. Let me hear from the team.
So, Minister, members, so with the operation of the Gun Court Act, there is a provision there that says if you are charged for this under this provision, and it is a matter of your license having had expired, that it would not apply. So once you would have had a license in relation to that firearm, the illegal possession provision would not apply.
Sorry, I didn't hear you at all. You're
saying, Senator, that in the Gun Court Act, if the person's licensed firearm is not licensed at the time, this particular provision does not apply, but I need to be sure if that's on, Is the structure correct? The wording, and I need advice.
And then
Ms.
the other concern that I have with it, when it says that in the parish court, a fine of not less than 3 million, that is establishing that there's a minimum. So the parish court can impose a fine of 10 million. It goes on to say not less than 3 years. The parish court can impose a term of imprisonment of 10 years. That does not seem to be, well, I've never seen any other legislation where the parish court can impose a sentence that even exceeds 5 years. And in respect to fines, I don't think I've seen one that the parish court imposes fines that go beyond 5 million. I think this one may have some 5 million, and there may be some others, but it just looks a little unusual when you say not less than. So it seems as if you are limitless in the parish court in respect to. So I don't know if I'm reading it correctly, but I'll be guided.
Senator Sinclair, in supporting you, it's a dissonance with how the others are framed, because the others actually say not exceeding. This is one that stands out of not less. So I think that it needs to be revisited.
I'm also
Thank you,
for
Madam S.
technical team is this here so to be consistent with the first part of the bill, the prohibited weapons, because if it's a licensed firearm and therefore this does not apply, then the other thing is a prohibited weapon. You know, it's just 2 firearms we have. One that was licensed and been through the system, and therefore, as you said, the gun court act could not apply. The other is the prohibited weapon. There's no in between. How does this clause apply in at all? Is it there to be consistent with the first part where the penalties are already outlined? But you would need it here again.
No, remember there are specific instances in which a firearm will be considered prohibited, and the prohibited, as outlined in the definition, would be any firearm in respect of which no firearm authorization is granted.
Yeah, that's I'm thinking. But so,
but the fact, though, Minister, if I were in possession of, are you saying that if I were in possession of a licensed firearm that was illegally transferred or stolen or something, that I would then be subject to?
But if they stole a firearm, the person who owns it then has a prohibited weapon.
No, that's not necessarily correct.
Well,
based on the scheme of how this is written.
Okay, the way you define it, yeah, I can understand, but it would have been treated the same level as a prohibited weapon. Once it doesn't apply, once this is not applied to firearms that are held illegally. That's what it is. The man steal a man's gun. It's as bad as buying it from it's worse than buying it from an illegal gun dealer. Yeah, but the treatment for it in the penalty. So it has to be the same as a prohibited weapon. Steal a man's gun, you're going to kill people. First, you steal a man's gun, which is one of acts, and you have it.
Can I?
Yeah, Senator, go
If
ahead.
a person, I'm on the same query with you, Minister. If a person, say, unlawfully took a licensed firearm, so he steals a licensed firearm, whatever he's going to do, whether he's going to try and sell it to some other person who obviously is not an authorized person or a licensed person for that particular firearm, or he's going to commit some other type of offense. Wouldn't that person then, in any event, if found with that firearm, fall into the first phase that gives him a 15-year minimum?
Yes. Yeah, but the same as
So-
Section 2 before a circuit court, you would go to a parish court.
Right. So that's why I was interpreting this. Is it that you're referring to the person was a licensed firearm but failed to do the licensing process, then that person is in breach and would end up before a parish court, possibly, and not the circuit court, in which case this up not less than 3 million and not less than 3 years sounds a little exorbitant for an administrative failure.
I'm the same thing you said. We are going through it with you, Senator, that for the licensed firearm holder who's failed to license, which we discussed earlier as well, another way, on time, it should be a fine for him to know you need to license firearm on time, period. But it must refer to the unlicensed firearm, or if he hands it to his family, he can also be charged for, there's another charge for that. You know, but if somebody steals it, then it has to be treated as Section 2. And it needs to be clear. Unauthorized possession, it cannot be unauthorized possession, but unauthorized possession, it needs some clarity. Okay. Technically, a man who did not license his firearm is not unauthorized. It's a breach of a license regulation, but that's a simple matter. You know, if he steals it, he goes to the next level, but it needs to be clear how you proceed from one to the other. I'm not sure how this is done.
All right, good morning, Chairman.
Yes. Go ahead.
Yes, morning, Chairman. Am I being heard?
Yeah, I'm hearing you.
Right. I believe that this provision was meant to capture once it is a firearm for which an authorization has been issued. It is meant to capture situations, for example, if a husband leaves his licensed firearm with his wife and goes somewhere, the wife would be in unauthorized possession of firearm. And the penalties are written in this way to give the judge a wide discretion as to what is an appropriate sentence for that kind of circumstance. So as drafted now, once the firearm is one for which an authorization has been issued, whether or not the firearm was stolen, whether or not the license holder deliberately left it with a family member or a friend, these are the penalties. So we drafted it in a way to give a wide discretion. So for example, if it is that the firearm was stolen, of course, those circumstances would be aggravated and it would go to circuit courts.
I understand that. Who just spoke? SG?
No, Alita Tomlinson.
Mr. Thomas,
JCS.
yes. No, what you have explained is what I understand. This should have related. It just wasn't, I wasn't seeing that clearly in the way it is structured. That the unauthorized possession of a license, like I said, the son has his father's firearm by maybe just leaving to them in the car or his wife. It has to be a fine. I mean, he can be charged. I don't think it's at that level necessarily. It's a fine.
Good morning, Chair.
It's a different ball game, so I just wanted to be sure that the way it's structured is for the legal mind is clear.
Good morning, Chair. This is Nadine Wilkins.
Yes, go ahead, Ms. Wilkins.
I'm noting that for 45, I think that this is unusual and unprecedented to say as the court considers appropriate. I think the parish court it is more customary for a specific provision to be made in the law. I understand what Alicia just said, but I still think that it needs to be specific.
I don't see a minimum for that either, because I said if the wife is apprehending the car and another person so decide that, look, I don't believe what you said, but the husband, I'm going to charge you. He goes to court and is found, you know, it was wrong for her to have begun without proper authorization. But in the circumstances, he may be fined $5,000. I don't know, a couple of licensed firearms were charged not long ago because they did something with a firearm which was out of line, but it was not a criminal intent. they still have a problem with their charge. Right? We'll have to look at the expungement. Okay? But it could be quite inadvertent. The husband drive off and leave the gun in the car, the wife drive the car to the supermarket and suddenly find she's in possession of the car for the day. So the first, I can understand what one means, but it needs to be clear. And I don't think you should have a minimum there.
Yeah, I think we have to look back at that. I think we have to look back at it.
SG, is it
And Minister, Chairman.
SG? I allow the SG to comment and then Lister will come back in, Senator.
Okay.
You raise the concern.
Okay, thank you, DPM, and morning to you and members and colleagues. Just to say that I actually do not support the formulation of the offense for 45(2). Number one, the offense as formulated will not ensure that there is a distinction in the jurisdiction of the courts. The parish court is not a superior court of record. We usually, Senator Sinclair is correct. The highest fines that we have imposed in law for a parish court is $5 million. The reason for this, we wanted to make sure there was a clear distinction between the jurisdiction of the parish court and the jurisdiction of the superior courts of record. The way this is formulated, in putting it as a minimum, it means then it would give it an unlimited jurisdiction, which is also not within the purview of the parish court. That is for a superior court of record. So the fine that, if there's going to be a fine, it should be done, recasted to do it as a maximum, and you put what the maximum sentence would be. And the maximum sentence should not exceed $5 million.
Thank you very much, SG. I think the formulation, yes. And I think, yeah, once you put maximum of $5 million, then they can go whatever limit they want and retain their flexibility. I think the maximum for imprisonment should be, if it's the kind of term we're talking about, maximum of 12 months, and the courts have to find, I know in many cases you'll not need an imprisonment at all. And then I'd expect the prosecution would take the stolen firearm to the circuit court and it is treated accordingly. So I agree. Ms. McCarthy, make note, and the MLS team, we have to reformulate one. Senator, you want to comment any further? Senator Sinclair.
Yes, as Minister. And also, when you look at what is contained in 45, which speaks to B, a firearm that is not marked in accordance with section 29(1). And 29(1) is speaking to a firearm imported into, exported, etc. shall bear a mark. Okay, well, probably that is just indicating and not the individual who may have imported it.
Yeah, we did go into that in some detail yesterday, Senator, if you recall.
Okay.
The meeting, and
I wasn't here yesterday.
We're done there as well. Yeah, some reforms will be done there with 29. But again, the same issue is as to what the firearm you're dealing with, because when it's imported, they have to declare on the invoice what is there, and if there's a variation, it could be the local persons who cause the variation. So you'd have to, it would be manufacturers or distributors' fault, and if it's consistent, then you'd investigate the local person more, not so much for the firearm, but for criminal conspiracy. So that has to be changed.
Right. So it just how it comes into play in respect to 45 to a firearm that is not marked in accordance with that particular section. Is it that we are still referring to if a firearm is imported and it is not marked, then this section is applicable, this penalty?
No, if it's imported and they have to be inspected by the FLA before this, so it will be seized. The section won't become applicable on the certificate position, which would be a different kind of position. The imported firearm has to be inspected by the FLA to correspond with what's on the invoice. So if it has no marking, all that happens is that you'll seize it. That's what we discussed yesterday at length. So it would not, there'll be no linkages. If it escaped the system, I guess you could find a person with a firearm that is not authorized.
So this seems to then be saying, this is referring to if you had a firearm which was registered, but when an individual is found with it, any of the markings that are referred to in 29.1 are missing, then he's subject to this penalty. Is that what 45.2 is getting at? So
May I assist with that? I think we need to notice something. Sorry to interject, Senator, but I think we have a situation where the offense is really at 34, and we already have an offense in the schedule. We already have a penalty in the schedule for 34. If you remember when we were discussing it yesterday, the offense is not in 29. The offense is in section 34 or clause 34. Right. And the schedule already provides for the penalty for the breach of clause 34. On summary conviction before a parish court, a fine not exceeding 5 million or imprisonment for a term not exceeding 5 years.
Okay, well, there you go.
And that was the subject of much discussion yesterday, as you would recall. So I think we have some double, we have this needs to be,
yes.
Yeah.
I agree with you.
Fact, the distinction between 34 and 45. 34 is meant to cover a situation of importation if the firearm would have been imported without the requisite mark. 45 is focused on the possession, because there could be importation but not possession. So it's two.
Yes, but 45 references 29.1 and 2.
So in relation to 45, if you're now in possession of a firearm that does not bear the requisite mark, that in and of itself is an offense. That's separate and apart from importation.
Yes, but I'm saying that the schedule, the offense that we have at 45.2 incorporates 29.1. It incorporates the importation as well.
But the reference...
So I'm just saying that let us look back at it and come back so that, you know, I think it needs to be looked back at. I don't know.
Okay, no.
That's my suggestion. Because
it may need to be looked back in respect to the not less, as well as in respect to 34, which speaks to it being a maximum, right?
Yeah,
because I understand the difference between the importation and the possession.
Certainly for the rewording, as the labor, I understand, it has to be changed, that not less has to be changed, that formula. I advise you. We're going to ask members to, when they're speaking, to turn on the cameras. That's for PBCJ. In this committee, all stars at work. All right, so I think we got that, and Mr. McCarthy make a note as well. MNS team will note the comments. 47.2, Ms. Grant, back to you.
47.2, carrying firearm or ammunition in a public place without authorization. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years.
Chair, I don't know why my video is not coming on.
What's that?
My video doesn't seem to be coming on.
Okay.
But I wanted to say that this, I wanted to understand. I wanted to understand the thinking behind this, because as I understand this section 47.2, that is where you have the firearm, but you do not have at that time the appropriate firearm authorization. So it's something that we discussed where you're in the place, you have your gun, but you forgot your license or so. Am I interpreting this section in accordance with what it intends?
I can weigh in on this, Member Scott Motley. So a responsibility is placed on all persons to whom an authorization is issued to have on their person that authorization when they are in possession of the firearm.
There's also an
Right, and that is why I'm looking at the penalty which is imposed.
Right.
Because it says on summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. Is that your intention?
So two things.
I know you want
two things. Hold on. Two things is that you know that this matter, when we place matters in the parish court, then we are treating them at a lower level simply because it's a jurisdiction with limit. But in the course of the deliberations, we had pretty much considered whether the penalty needs to be at that level, firstly, as well as whether, in addition, we could deal with it administratively. There is going to be a penalty, but I think it is generally agreed that we could allow for a delay in the prosecution to enable persons to provide, to show their authorization. And I think one of the members had put on the table consideration as to whether something administrative by way of an administrative penalty could be imposed at the time of either renewal or at some stage. But bear in mind, so those are under consideration, but bear in mind that there is a duty that is placed on licensee permit holders to have with them the authorization that is duly issued. But it is a proper question as to whether we would want to put the penalty at a lower level, even though in the parish court.
I recall the discussion in detail.
There are two.
Yes.
Sorry to interrupt, but there are two aspects. The discussion we had clearly made that, and as the Minister pointed out, we're looking at a different regime or scheme of holding the person accountable who don't have the license them at the time. But by going on to say in a public place for which they need authorization, if they are found, say, inside the airport, the back end of the airport, without permission to be there with a firearm, or in a space, say in Jamaica House, a civilian walks in there where it is not authorized them to carry a firearm, or even Parliament, it's a different approach than if they don't have their license on them. There are places for which you're not supposed, you have to get permission to carry your firearm authorized. Not just your firearm authorization, but authorization to be there. So I think that needs to be borne in mind, but definitely has to be a wording that separates the two. The issue of having your authorization is this, and that is an administrative penalty. Because you're the police stops you on the road, you don't have your license, you're given time, and the fines are different from going to court and be criminalized. But if you are found in a place, you have to give a reason if you walk into Parliament as a civilian with your firearm, whether you're there to shoot somebody or you just by accident bring it in, and that's where you go to court to prove your intent.
Chairman, just to point out that what we have done is to create a special summary statutory jurisdiction in the parish court, which takes it above the general jurisdiction in respect of this matter. Some of them fall in the general jurisdiction of the, I think it may be 1 million, but we have put it between up to a $5 million monetary penalty jurisdiction. 5 million and I think 5 years. So that is the special statutory summary jurisdiction that is conferred on the parish court for matters of the firearms law. But we did, I think, discuss another look at the level of penalties, particularly for the offense of failing to have the authorization on your person.
Oh, that I'm going to give Minister. I said there are two categories of authorization we're looking at.
Right.
In terms of places.
So the restricted area is going to be treated very differently and that's right. That's a strict liability matter, but generally outside of the restricted area, the special restricted area.
And in the special restricted area, as a licensed firearm holder, you still have the flexibility.
Yes, that is, yes.
Parish court to prove is in a sense that you're not
No, nobody proves their innocence. DPM, an important distinction. Guilt is proven. Persons cast a doubt on the prosecution's case, reasonable doubt.
But Chairman, my own view is that the penalties for some of these sections where the person is a firearm license owner does not really capture what I think ought to be intended. And I'm jumping ahead just a bit to show you how it is that it is evolving. So the 48.2, which is a requirement applicable to persons authorized to carry firearm in public place, as I look at it, it is that there's a requirement in 48 that the person shall conceal the firearm. But a person who contravenes it commits an offense, and that offense is summary conviction before a parish court and a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years.
Well, remember Member Scott Motley, that it is not a fixed, right? It's the outer limit. It's not exceeding.
Minister, what I'm saying is that if the licensed firearm owner is in breach in that way, in other words, he should conceal his weapon. And for some reason, say his shirt goes up or something happens and his weapon is not concealed. Is that really what you want? How you want to treat somebody?
No, not at all. But bear in mind also that on the prohibition side of the law, those matters are not placed before the parish court at all. So the fact that a special statutory jurisdiction is given to the parish court is also an indication of the intention to treat with them at a lower level, even though, of course,
I think you're missing my point, though, because I'm not.
No, I don't miss your point at all. Two things I gather you're asking for. You're looking on examples of how the offense can be committed, and also whether we still would want to put the penalty, the maximum penalty at that level. That's my understanding of the points you're making.
I'm really saying that based on our extensive discussions we've had, do we want to impose an administrative fine or some kind of penalty, or do we want the person put before the court? I think it's very important for us to consider that, especially as we are distinguishing between the two categories, the licensed firearm holder and the illegal holder.
But where a statute creates an offense is tried before a court. So that what you want is that where you have a breach, you don't resort to prosecution in the first instance. And you would, and like any courts, I'm a little troubled.
And that is where I want to take you. That is exactly where I want to take you. Because at the first instance, is there some other way to deal with the matter?
Right. So we would have recommended that you give a time before which a prosecution could commence in order to enable persons. So if, for example, I mean, we have to give room for, notwithstanding the genuine concerns that exist, that persons are upholding the law are trained persons, and their training is becoming better day by day, so that if a firearm is exposed, someone can sit up and it becomes exposed. That does not mean automatically that an officer looking on. The first point is to grab the person and charge them. All right, a person becomes aware of it. You are given, you are spoken to, perhaps to say, bring it to their awareness if they are not. And if a warning is required, if it can be done before you get there. But you You may have
Minister,
cases where a firearm is exposed perhaps to cause intimidation in others, even by a licensed firearm holder. Expose that impact the state of public order in an area. So yes, it is the policy to impose the duty on a license holder to conceal the firearm and to make it an offense. But you know, for any offense is not an accidental exposure of it. It's a deliberate exposure of it. And other things.
Minister, well, I think we're.
So, Minister,
Sorry, Senator. I was saying, Minister, you're finished? Minister Ford? Minister Ford, Minister Ford, you're finished?
No, I'm still here. I just muted the mic.
Oh, sorry, you're finished. No, I was saying both points are raised. You know, the policy of holding the person accountable if they, as I said, they could expose their firearm in an area as a matter of intimidating personnel, which is a criminal offense. But the other side of it, there has to be some separate how you get the process, as I said, get to this point, because the Criminal Records Act now, which was amended, and I think Senator Sinclair some back in a few years back, which does not allow expungement for breach of the Firearm Act. And if you have a person who, if the officer charges them rather quickly, as I think we have, if I don't want to allude to a case, but the court may see that this was quite an innocent exposure.
Minister.
They charge him $3,000, but you still have a record of having a conviction for a firearm. So I think what they need, as Home Minister, what we need is that the entire structure must indicate that there has to be some process before you get to the point. The charge is laid that if it is an innocent exposure, an inadvertent exposure, he is not charged. And end up, he pleads guilty, but he still has a firearm charge over his head, which cannot be expunged. On the other hand, if it is being exposed to create fear, and that's a serious charge, and therefore this would apply.
So, Minister,
so both comments are valid. Is how you structure it.
Right. So there is policy space to rework the provisions, because the policy is to treat licensed firearm holders differently, and where offenses are committed is not to view them on the same level as, depending of course on the type of offense, as those on the prohibition side of the law. It would be a matter for the MNS, and the team to just look at it again, because I think there is general agreement around what we're seeking to do. The concern is whether unwittingly you may cover something that is not meant to cover. So, as I always say, great scrutiny has to be taken to ensure that what eventually passes as law is what is intended, because in the worst case scenario, you are going to meet the worst consequences of it.
Yeah, that is the clear policy of separating the two, which is why as we move into this, the penalties and the offenses and accountability section, we have to look carefully at how we do it for the licensed firearm holder who has gone through a due diligence. And all
right, DPM, I'm going to ask to be excused for a little. I will come back on again because I'm just at a function, but I will come back on shortly.
And I must say to the team that the ministry team has been asked to look at a fixed penalty regime for a number of things. I think that will have to come out in the review as we go forward. We applied a lot of time and intellectuals to get the separation and the structure we have, but maybe a little more time out to be spent on the licensed firearm holder, how we hold them accountable now, because there has to be accountable, but they go through a process of due diligence to get the license, which we have actually strengthened in this law to make sure that the person who receives a firearm license is of adequate, let's say, satisfactory integrity and emotional state, etc. So we have to look at how we structure the penalties and make them clear. Certainly, I said if someone exposed their firearm in public space as in a view of threatening somebody or exerting the authority, different from inadvertent exposure. And the concept of a fixed penalty regime needs to be explored before we finalize the bill. And I think there are a number of other areas, Senator, you have raised. Going through the bill,
Chair?
that we'll have to have the same issue. Senator,
Mr. Chairman,
Senator Golding? Yeah.
can I just ask for some clarification, because what Minister Fort just said in relation to the treatment of the two regimes, the illegal weapons holder and the licensed firearm holder.
Right.
If in a circumstance like this, and I'm talking about 48, whether or not I have a license, if I deliberately expose my firearm, I'm not sure that the policy should see a distinction between a licensed firearm holder who deliberately exposes the firearm for the purposes of intimidation versus an unlicensed, unauthorized holder. And so I wonder if the mischief would not be corrected by some language in there that speaks to intentionally exposing, which would then trigger an offense to be prosecuted by the court, so that the person who is a licensed firearm holder, who, you know, suffers a gust of wind that lifts his shirt and he's not aware that the firearm is exposed, would not then be captured. I commend that to the committee for consideration.
Yes, we have to, we're on the same line, Senator, that the person who exposes a firearm, even if he's licensed for intimidation, a different charge, as different from an illegal prohibited weapon. But he's also a different charge from the one who exposed it inadvertently. As I said, in one case, it might be a once it's exposed for intimidation, but the parish court has the flexibility to decide what level of punishment. On the other hand, if it's exposed inadvertently, then it should be an administrative charge, because it's a somewhat of a bit of carelessness, which he might not even be responsible for. You charge him, once he's charged on the act, it's a serious indictment on him, and it remains with him for life, unless we proceed to amend the Criminal Records Act. So the team will be asked to look at it. Ms. McCarthy, you make a note of those. And there might be other recurrent incidents as we proceed, because I said, I think the distinction between the two may not have been maintained as sharply as we would like. So we'll look at them as we proceed. We have covered interrogated 48.2. Any other comments? If not, we move to 49.2.
49.2, carrying firearm or ammunition in a restricted area without authorization. 1, on summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 2, on conviction before a circuit court, a fine or imprisonment for a term not exceeding 10 years.
Again, I assume that one would be referring would be the licensed firearm holder who may deliberately or inadvertently enter a restricted area with a firearm, as opposed to 2, where the person is entering the area to intimidate or carry out a felon. And that the prosecuting team would be able to recognize the separation, right? And in the first case, again, I don't know. You see, for example, well, the term not exceeding 3 years, I don't know come to feel about it for Section 1. The airport is a restricted area now. I have to give authorization to carry a firearm in the airport. Now, if a person walks into the airport with a firearm, you know, you want to put over the head up not exceeding 3 years. I know it's not exceeding the court's discretion. But again, you want to maintain flexibility there for those who are seeking to use a firearm in an illegal manner, as those who might have inadvertently reached there. We should look at that. 52.2.
52.2, failure to deliver of firearm or ammunition. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 53.2, failure to report lost or stolen firearm or ammunition. On summary conviction before a parish court, a fine not exceeding $1 million or imprisonment for a term not exceeding 1 year. 54.2, failure to report possession of lost or stolen firearm or ammunition. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years.
Ms. Grant, in 53.2, would we put a time limit on that? Is there in the, is that in 53.2? 24 hours? That's kind of short, you know. Again, is a 24 hours of discovering it. Okay, all right. Can work with that. Go ahead, Ms. Grant.
54.4, failure to report location of lost or stolen firearm or ammunition. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 57.3, making false declaration in firearm authorization application.
Right, can I comment, Mr. Chairman?
Go ahead,
Let me see
Senator.
if I can get on.
Yeah, go ahead, Senator.
All right,
Yes. Yeah,
you
sure
have,
no. Senator
yeah.
Butts is a handsome senator on the screen.
Yes, definitely.
Thank you, Madam Scott Motley. When I look on the failure to report lost or stolen firearm and what you're proposing as a sentence of $3 million, and I compare it with, for example, the
Authorization.
exposure of a weapon that we dealt with in 48. Now, this is where you have the weapon not being concealed, and we heard examples of it. Your clothing may have been blown apart by the wind and you didn't realize. But you have a penalty of $5 million, not exceeding $5 million. But if a person's firearm is lost or stolen and they fail to report it, you're putting it at not exceeding $3 million. The two don't seem to, I think they should be switched around. Well, if you know that your firearm is lost or stolen and you fail to report it, and the maximum you can define is $3 million. But if you are in a public place and your clothes got a bit distorted because of whatever, and you are not aware and police sees you, you are potentially facing a fine of $5 million.
That's what I'm saying, Senator, and if you're at least that all those.
Yes, I understand, but even if you put them into
a
fixed penalty
regime in for them.
Yes, but even if you put them into a fixed penalty regime, is it that you're going to be reducing the sum?
That's reduced. A fixed penalty regime you're talking about.
To reflect the seriousness of the particular breach. Yeah.
I said, if the person at the airport and the wind blows his jacket and exposes his firearm, in fact, it should, if there's a charge at all, should be administrative. It can be charged with a firearm offense, which, as I said earlier, from your own advice, been talked there. If he gets charged with Firearms Act, the Criminal Records Act prevent him from even being expunged. So even if the court sees that this is a very mild offense and charge him $3,000, he still has a conviction.
Yes. Yes, but you don't. What I'm saying still is that the person can be exposed to the administrative fee. The administrative fee would not be $5 million.
No.
Compared to where a person loses his firearm and although you
No,
may get a
report it.
criminal conviction for that, but then the maximum that the person can face is a $3 million fine.
No, I'm with you on that, Senator. I think the team technically have to look at this, how they, to ensure consistency and a kind of proportionality across the system.
Yes.
Similar to from making a false declaration, I think is more serious than not if you forget to report within 24 hours. Because if you make a false declaration, meaning you're seeking to deceive the firearm authority. That's a serious offense. I should carry a heavier penalty than one who, having discovered today that his firearm is lost, get there a day late. The police
I
station.
should not be any less than failing to report it.
No, it has to be the same. Yeah, it's a serious.
Chair,
Yeah.
actually the failure to report on the part of the holder of the authorization is the offense in 54.2, which is, sorry, 53.2, which is 1 million. 54.4 here is dealing with some other person who knows the location, and that is 3 million. So there's also some discrepancy there.
All right, but we just to resolve the discrepancies, but also I said making a false declaration is a more serious offense because it intends to deceive, and therefore one can almost assume intent to do something wrong. It must be at least the same level as any of the other breaches mentioned above. 57. All right, so again, Ms. McCarthy and technical team, Mr. Richards and team, make the do. These are just resolving some discrepancies, I think. All right. But thanks again for the comments, Senator. I think we recognize that, and some corrections we made to this before we finalize the bill. 71.5.
Failure to surrender license, firearm, or ammunition. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 72.3, failure to comply with notice to deliver license, certificate, or permit to the authority for requisite amendments. On summary conviction before a parish court, a fine not exceeding $1 million or imprisonment for a term not exceeding 1 year. 73.
Ms. Grant, again, this one, 71 and 72, is that in line? One, yeah, you should surrender it on the. Okay, I've been told the license is revoked. But in 72, is that an order to deliver? It should be the same penalty. All right. Go ahead, Ms. Grant.
73.5, failure to submit firearm for registration. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 74.2, breach of duty to securely store firearm and ammunition. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years.
Did we have some discussion on this? Failure to submit for registration.
We did in a chair.
Yeah. Can you remind me of that too? Because I think there was some concern about the time to register and the level of penalties here. Yeah, I remember there was a discussion here. There's some thought to review the penalty, and because this registration within a 3-year period, which we have reduced it to 3 years from 5 years. And the minister has a right to extend that by affirmative resolution. But even so, the penalties, I think we're looking at that.
Another issue that they had with the provision, Minister, was the 30-day period
Right.
that we had prescribed, that 30 days before the birthday, that the consideration was to also give an additional 30-day grace period after the birthday, within which the individual would bring in the firearm for
Yes.
registration.
And do you need imprisonment for that?
Well, to also include without reasonable excuse as well within the offense creating provision.
Yeah, well, reason.
Can I ask that the person speak up a little louder? I'm not hearing a thing.
Go ahead. Sir, this is the issue we had discussed before, Senator, the failure to submit firearm for registration and to secure the firearm, whether these should carry imprisonment levels, and I think all of us agreed to that would extend the period instead of 30 days, would extend the time for them to give them to register in terms of not renewing their license. And there was a registration period which could be extended by affirmative resolution after the appointed day of notice for this bill. But there was some concern about the imprisonment for that, if I recall correctly. All right. Yeah. But this is not one way. This is a licensed firearm holder. These are things we're considered under fixed penalty as well. So I think we need to note that, because to ask the gentleman to, I think there can be a fine if you have to be charged, but the fixed penalty regime, I think, was discussed in relation to this. So I just want that to be noted again, Ms. McCarthy.
Mr. Chairman.
Yes, Senator.
When we had this, we discussed this actually a couple of times.
Yes.
And I thought the agreement was
a fixed penalty regime.
So that if a person, say within 90 days beyond the birthday, that instead of their renewal being, say, 12,000, we would make it 3 times that.
That's a fixed penalty regime.
With an administrative thing. That would be similar to, I think, the ticket, the traffic ticketing, where if you don't pay it within a period of time.
But this is a fixed penalty regime was discussed for this. That's why I read it. So I would
right. And but I would also add that I would have no objection if at some point, whether it be 6 months or a year, I mean, if the person was persistent in not doing it, then it becomes, then it falls back on some kind of criminal offense. But certainly not within a 90-day period. I think that should be just an administrative offense.
Fixed penalty regime is a ticketing system. So the timeline would, it could be $20,000 for the first 30 days, $6,000, and so forth. So the fixed penalty regime will be what we have examined. For criminal offense, I think you'll have to allow that to be examined by the police.
So if I may, though, Minister, with respect to fixed penalty regime, what would happen is if the person does not pay the fixed penalty, and we'd have to then specify a particular period, then they would become liable for prosecution, which is what happens with most fixed penalty regimes. But my recollection of the discussion was for us to actually reconsider this subclause in relation to the offense creating section, as well as to include without reasonable excuse, as well as no prosecution will take place within 30 days post the 30-day duration, which is
we make a 60-day period. Yeah. All right. I think we can live with that. And I said the critical thing is to get this. I think we also, some of these penalties were kind of a legacy issue, which to get the differentiation between the licensed and the prohibited weapons. So we'll continue to look at it. A number of these will come up, and we'll just clarify them and go on. And I think this has been thoroughly interrogated, and we'll proceed along those lines, which is fixed penalty and a time span of 6 days before any prosecution is started. And we are prosecutors. There has to be investigation to show that there was intent. All right. All right, Senator, we can move on then to 75-2.
75-2, manufacturing or dealing in firearms or ammunition at a place other than that specified in a firearm manufacturer's license, a firearm dealer's license, or a firearm broker's license. On A, summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. Or B, conviction before a circuit court, a fine or imprisonment for a term not exceeding 10 years. 76.8, failure to keep records or knowingly making a false entry in record. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 77.2, failure to display notice as required. On summary conviction before a parish court, a fine not exceeding $500,000 or imprisonment for a term not exceeding 6 months. 78, contravention of the terms and conditions of firearm authorization. On summary conviction before a parish court, a fine not exceeding $1 million or imprisonment for a term not exceeding 1 year. 79.3, failure to properly store firearms and ammunition. On summary conviction before a parish court, a fine not exceeding $1 million and in default of payment thereof, imprisonment for a term not exceeding 1 year. 82.3, failure to comply with notice to deliver firearm and ammunition to authority. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 83.5, failure to comply with suspension notice. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 84.4, failure to comply with a revocation notice. On summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 90, subsection 2, failure to comply with a request by a constable to stop and search a conveyance or intimidating or preventing the driver of a conveyance from stopping at the request of a constable or escaping or attempting to escape from a conveyance requested to be stopped by a constable. On summary conviction before a parish court, a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years.
CPC, through you, Chair, can I ask the justification for this fine of $2 million, a term not exceeding 2 years? If a constable has ordered a conveyance to stop and the operator or any person in the conveyance, the operator fails to stop or a person prevents or intimidates the operator from stopping, why is this fine so mild in comparison to some of the others we've discussed this morning? Because that person is acting to evade the law. Why would we be milder with them than we would be, for instance, with let's say somebody carrying the firearm in a public place under 48 or 47? Because that seems to me to be an egregious offense if a constable has asked you to stop. Can the tech team opine on the justification for that?
Yeah, go ahead. Sabrina, I'm sorry, Richard. Yeah. You're gonna, yeah, we look at that. Bear in mind, the only recent case we had was taximan was running away because he had too many tickets. Not to you, but I agree with you that this has to give the maximum should be increased, right? It's the parish courts. There has to be, because it's quite a certain person have an intent, but you leave the flexibility there in the parish court that if it's a simple.
Remember in a chair that it's not that the constable is stopping the conveyance for some other reason. He's stopping the conveyance because he suspects that there's a firearm there. Yeah.
I've accepted
Yeah.
to do that. I just mentioned that a little bit lightly.
Yes, appreciate it.
Tickets cause quite a bit of a furor. Okay, but we take note of that, Mr. McCarthy, and I think the technical team has accepted that there need to be some realignment with the other penalties. 93.3.
Failure to produce firearm authorization. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 94.4, failure to comply with requirement to produce concealed firearm, etc., or falsely declaring name or address to a constable. On summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 104.4, breach of duty of confidentiality. On summary conviction before a parish court, a fine not exceeding $1 million or imprisonment for a term not exceeding 1 year.
This among those who said would delay prosecution and give them time to find the authorization, right? 93.3. Okay, that takes the end of schedule, the 6th schedule. We have made some administrative changes, I think. I think the technical team have noted all of them, and Ms. McCarthy will know them, so time with that, but they're not difficult things to do. These are more straightforward. Which is more to prevent discrepancies and also to allow and pay some respect to the properly authorized license holder for inadvertent errors. 7th schedule, did we go through this before? I think.
No, this is the final schedule. We hadn't gone through. It's the other enactments, and the original provisions of those enactments are in the left-hand pages at the back of the bill.
All right.
So amendments to the Criminal Justice Administration Act. In section 42C, delete the word or at the end of paragraph B, delete the full stop at the end of paragraph C and substitute the word or, and that's to facilitate the insertion of this new paragraph D, which reads, an offense under part 2 of the Firearms Prohibition, Restriction, and Regulation Act. Amendment.
Lawyers can complete here.
So
Senator.
Chairman.
Yes, go ahead.
Perhaps they, Ms. Grant could also indicate to us at the same time, and for the records and for persons listening, what effect that has on the legislation which is being amended. A brief indication. So, for example, what's the import of that insertion at paragraph D?
All right, Ms. Grimes, not too much.
Senator,
brief. Don't want to overload you. I was just saying that the only person who can comment on these are the lawyers, because I don't know the but you could make a short comment, Ms. Grimes. Okay.
Chair, just before you do that, just to draw your attention, the original provisions that are being amended, which CBC alluded to, that first one, section 42C of the Criminal Justice Administration Act, I don't see that outlined in the original provision set out at the back. Am I? Yeah, I haven't seen that. So that one might have been omitted.
Delete the word or at the end of paragraph B. Is that the reference you're referring to, Senator?
Right. So section 42C is not, that original provision isn't outlined there. The others are.
Oh, I got a member Davis is on. I want to make a comment there.
Thank you, Chair. It really was the same comment as Senator Scott Motley, that we really ought to put it in context, because merely reading this as it is would not give us any idea as to the effect it will have on the bill.
Okay, thank you. Okay. CP. Grant. Mr. Bailey will respond. Yeah. Yeah, right. Go ahead.
Yes, thank you. So, yes, the extract of the Section 42C of the Criminal Justice Administration Act was omitted from the left-hand pages, but that provision provides exceptions to Part 1A, which deals with reductions of sentence upon guilty plea. And so it sets out the various provisions to which that part shall not apply. Currently, the exceptions are A, the offense of murder falling within Section 2(1) of the Offenses Against the Person Act. B, the offense of murder in circumstances where Section 3(1)A of the Offenses Against the Person Act applies. Or C, an offense following plea negotiations and the conclusion of a plea agreement pursuant to the provisions of the Criminal Justice Plea Negotiations and Agreements Act. So this provision now adds a new subsection D, which would exclude from the application of Part 1A an offense under the Firearms Prohibition, Restriction and Regulation Act.
Okay, thank you.
Amendment of the Explosives Control of Manufacture Act. In Section 9, delete all the words appearing after the words shall be and substitute therefore the following. Liable therefore on conviction before a parish court to a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years, or B, a circuit court to a fine or to imprisonment for such term of not less than 5 years as the court considers appropriate. So this is just a realignment of the penalties. Amendment of the Extradition Act. In Section 5, insert the following subsection next after subsection 3. An offense under any of sections 5, 6, 7, 8, 9, 10, 12, 13, 16, 17, or 34 of the Firearms Prohibition, Restriction, and Regulation Act is an extradition offense for the purposes of this Act and shall be deemed to be committed within the jurisdiction of any treaty state that appears to a court in Jamaica, having regard to the provisions of the conventions referred to in column A of the schedule to be appropriate. So that speaks for itself. It's adding those reference offenses as extraditable offenses. 2, in the schedule, insert the following as item 12 in columns A and B, respectively. 12, the Inter-American Convention Against the Illicit Manufacturing of and Trafficking in Firearms, Ammunition, Explosives, and other related materials adopted by the Organization of American States on November 14, 1997. And column B, 12, insofar as Article 4 of that convention requires. So that is adding the relevant convention for the purposes of the Act. Amendment of the Forgery Act. Delete Section 5(1) and substitute therefore the following. Forgery of certain documents with intent to defraud or deceive. 5(1), forgery of the following documents, if committed with intent to defraud or deceive, shall be a felony, and on conviction before the circuit court shall be liable. Shall be liable to imprisonment for life. A, any document whatsoever having thereupon or affixed thereto the stamp or impression of the, that should be broad seal of Jamaica, the Great Seal of the United Kingdom, Her Majesty's Privy Seal, and any privy signet of Her Majesty, Her Majesty's Royal Sign Manual, and any of Her Majesty's seals appointed by the 24th article between the Union, Article of the Union between England and Scotland to be kept, used, and continued in Scotland, the Great Seal of Ireland or the Privy Seal of Ireland. B, a firearm authorization granted under the Firearms Prohibition, Restriction, and Regulation Act. So that serves to add firearm authorizations to the types of documents for which the particular offense under Section 5 of the Forgery Act applies. In Section 8.1, delete the full stop at the end of paragraph B and substitute therefore a semicolon, and B, insert next after paragraph B the following: the seal of the firearm licensing authority. Right, and so that adds to the list of offenses in Section 8, which deals with the forgery of seals if committed with the intent to defraud or deceive, which should be a felony punishable with imprisonment, with hard labor, or for life. Sorry, with hard labor for life. 3, insert next after Section 9 the following section. 9A, forged firearms authorization. 1, every person who has in his possession or custody any document intended to resemble and pass off as a firearm authorization granted under the Firearms Prohibition, Restriction, and Regulation Act, or makes, uses, or knowingly has in custody or possession any seal, die, or other instrument for making such document, or for producing in or on such document any words, figures, letters, marks, lines, or devices peculiar to and used in or on any such firearm authorization, commits an offense and shall be punishable on indictment in a circuit court by a term of imprisonment not exceeding 25 years. Who a person shall be deemed to have in his custody or be in possession of a document, seal, or die, or an instrument for making a document, seal, or die, if the person A has such document, seal, die, or other instrument in his personal custody or possession, or B knowingly and willfully has such document, seal, die, or other instrument in the custody or possession of any other person in any building, lodging, apartment, field, or other place or conveyance, whether open or enclosed, or whether occupied by himself or not. Right, so that's a new provision which speaks for itself. Amendment of the Gun Court Act. In Section 2A, delete the definition of firearm and substitute therefore the following: firearm means a firearm or prohibited weapon as defined in Section 2 of the Firearms Prohibition, Restriction, and Regulation Act. So this serves to adjust the current definition of firearm in the Gun Court Act, to which now relates to the existing Firearms Act, and we're replacing it with a reference to this new Firearms Act. B, delete the definition of firearm offense and substitute therefore the following: firearm offense means any offense under Part 2 or the 6th schedule of the Firearms Prohibition, Restriction, and Regulation Act. So similarly, replacing the offenses on the reference to offenses under the proposed repeal act with references to this new act. But Chair, I do believe that there might be a little adjustment needed here. The reference there to the 6th schedule might be too wide, in that the 6th schedule also includes an offense under Section 104.4, which is a breach of the duty of confidentiality. So we might want to consider whether or not that is an offense that should be brought before the Gun Court.
Thank you. CP will make note of that, Mr. McCarthy. Mr. Richards, please. Required adjustment. We'll make the required adjustment, CP. Thank you.
B, any other offense whatsoever, including a firearm in which the offender's possession of the firearm is contrary to Section 45 of the Firearms Prohibition, Restriction, and Regulation Act. So again, that replaces the reference to the corresponding provision in the existing act with a reference to the provision in the new act. Amendment of the Gunpowder and Explosives Act. In Section 3, insert immediately before the word ship, wherever it appears, the word aircraft. B, delete the words, he shall be liable to a penalty of $200, and substituting therefore the words, he commits an offense and is liable on conviction before a parish court to a fine not exceeding $3 million or to imprisonment for a term not exceeding 3 years.
Okay, continue.
Right, so we're just expanding
Penalty, the $3 million.
to include a ship. Currently covers, aircraft currently covers any ship, door, or other vessel arriving in any ports of the island. And B, updates the penalty. 2, in Section 4A, delete the words under penalty not exceeding $200 for each offense. B, renumber the section as Section 4.1 and insert the following as subsection 2 of the section. 2, a person who contravenes subsection 1 commits an offense and shall be liable therefore A, on summary conviction before a parish court for a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years, or B, on conviction before a circuit court to a fine or to imprisonment for life or for such other term of not less than 15 years as the court considers appropriate. Right, so that updates the penalty there as well.
Go ahead, ZP.
In Section 13, delete all the words appearing after the words may be forfeited and substitute therefore the words commits an offense and is liable on conviction before a parish court to a fine not exceeding $1 million or to imprisonment for a term not exceeding 1 year. So that's an update of the penalties.
CPC, I'm begging you to look at that again, just to see if it reads at the point of where you're inserting it. So in the event of any breach by any act or default of any general rule in this section, the gunpowder in respect to which the breach is committed may be forfeited. Commits an offense is what's supposed to follow. Doesn't quite read to me.
Yeah, I think the words should have been substituted after the words and the person guilty of such breach.
Yes. Yes, agreed. Thank you.
All right, thank you.
Agree that stylistically, we would not have the term as the court considers appropriate. I thought we had agreed that in a previous one as part of it. we had looked at, was it 45.2 it has, as the court considers appropriate? Would that go without being spelled out?
That was discussed at one stage, CPL. I remember.
Senator Scott Motley, can you just identify exactly where you are?
That's the question. What was the invasion of the parish court only, and could it be used in the case of the circuit court? I think in the case the parish court was left not exceeding X. In the case of the circuit court, there was some. Again, I'd be advised. There was a discussion, I know, sure, for the parish court, we had asked that to be removed.
DPM, we're hardly hearing you. You're very low.
Sorry, I'm saying, I know the term, as the court considered appropriate, was removed from the parish court situation, and because there are limits there. But it was, I don't know if it was discussed for the higher court, but I'd be advised. Clearly, it sounds a Senator yesterday, you would just leave it for a term not less than 15 years, and the court will decide accordingly, right? Mr. Grant, is that the appropriate language? Or it doesn't matter?
Well, as long as you're keeping the words of not less than 15 years, then the words, as the court considers appropriate, would have to follow.
Okay.
I'm guided by you. I think we had made a change. You say it's only in respect of the parish court. But I thought it was clearly understood that a court could only give a sentence that it considers appropriate.
Ms. Grant, any comment there? Because I'd be advised here.
It's connoting a discretion simply because of the way it's phrased as such other term of not less than 15 years. So it's connoting a discretion. It's different from, for example, if we were to say not exceeding 15 years, because then it would be clear that the discretion goes up to the maximum of 15 years, but you're dealing here with the minimum.
And it's his style, so it seems, so that'd be advised on it. Okay. Note. Explanation seems satisfactory, Senator. So we could take 3 in section 13. Continue, CP.
Section 4 in section 18, delete the word firearm wherever it appears. B, delete all the words appearing after the words contrary to the provisions of this act, and substitute therefore the following. Shall A, on summary conviction, therefore, before a parish court, be liable to a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years, or B, on conviction, therefore, before a circuit court, be liable to a fine or to imprisonment for such term of not less than 15 years as the court considers appropriate. 5. Insert next after section 18 the following. Section 18A, use of gunpowder or dangerous explosive to maim or disfigure, etc. A person who uses gunpowder or a dangerous explosive with intent to maim, disfigure, or disable an individual or to endanger life or cause damage to property commits an offense and shall be liable on conviction, therefore, before a circuit court, to a fine or to imprisonment for such term of not less than 15 years as the court considers appropriate. So that's the insertion of a new offense. 6, in section 19, delete the word shall be liable to a penalty not exceeding $40 and substitute therefore the words commits an offense and is liable on conviction, therefore, before a parish court to a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years. So again, the penalty is updated. 7, delete section 23 and substitute therefore the following. 23, general penalty. Where a person commits an offense under this act for which no penalty is specifically provided, the person shall be liable on summary conviction, therefore, before a parish court to a fine not exceeding $3 million or to imprisonment for a term not exceeding 3 years. So that updates the penalty. Amendments to the Offenses Against the Person Act. 1, in sections 13, 16, and 17, insert next after the words hard labor, in each case the words, and in any case where the offense is committed with the use of a firearm, as defined in section 2 of the Firearms Prohibition, Restriction, and Regulation Act, the term of imprisonment imposed shall not be less than 15 years. 2, this paragraph should be aligned as a paragraph 2. In sections 29 and 30, insert next after the words hard labor, in each case the words, and in any case where the offense is committed with the use of a firearm, as defined in section 2 of the Firearms Prohibition, Restriction, and Regulation Act, the term of imprisonment imposed shall not be less than 10 years. So these provisions insert a specific penalty in the case where a firearm is used to commit the offense. Amendment of the Pawnbrokers Act. 1, in section 28, delete the word or at the end of paragraphs A, B, C, D, F, and G. B, renumber paragraph H as paragraph I and insert the following as paragraph H. H takes a firearm or ammunition as those terms are defined in the Firearms Prohibition, Restriction, and Regulation in Act, in pawn or. So this adds a new offense to the existing section 8 in respect of a pawnbroker who takes a firearm in pawn. Two, delete section 34 and substitute therefore the following. 34, cessation of license on conviction. If a pawnbroker is convicted of A, any fraud in that pawnbroker's business, B, receiving stolen goods knowing them to be stolen, or C, an offense under section 20H, the court before which a pawnbroker is convicted may, if the court thinks fit, direct that the license of the pawnbroker shall cease to have effect, and the license shall cease accordingly. So this amendment just expands the existing section 34 to include that offense of taking a firearm in pawn. Amendment of the Plea Negotiations and Agreements Act. In section 5, insert the following as subsection 2A. 2A, in the case of an offense under Part 2 of the Firearms Prohibition, Restriction, and Regulation Act, the obligation specified under subsection 2A2 shall include the provision of information that assists the Crown in the prevention, detection, or investigation of, or in proceedings relating to the offense concerned or any other offense. Right, so that provision is not included in the left-hand pages, but the existing section 5 of the Plea Negotiations Act provides the conditions that are necessary or that should be included in the plea negotiations agreement. So to an agreement under subsection 1 shall require that A, the accused person undertakes to 1, make a guilty plea to an offense which is disclosed on the allegations on which the charge against the accused person is based or the facts as agreed, and 2, fulfill the accused person's other obligations, if any, specified in the agreement, and B, a prosecutor agrees to fulfill the other obligations of the Crown specified in the agreement. So this is adding in the case of offenses that the person should provide information that assists the Crown in preventing, detecting, or investigating proceedings relating to the offense concerned or any other offense. Amendment of the Public Order Act. 1, in section 29(1), delete paragraphs A and B and substitute therefore the following. A, if the offense is committed at a political meeting, shall be liable on conviction, therefore, before a parish court for a fine not exceeding 5 years or to imprisonment for a term not exceeding 5 years, or 2, a circuit court to imprisonment for a term not exceeding 10 years. B, in any case not falling within paragraph A, shall be liable upon conviction, therefore, before 1, a parish court to a fine not exceeding $3 million or to imprisonment for a term not exceeding 3 years, or 2, a circuit court to a fine or to imprisonment for a term not exceeding 10 years. So that's updating the penalty. The Town and Communities Act, in section 3N, delete the words "want only discharge any firearms" or I think that should be "want only." There's a space there that shouldn't be there. So it's deleting the words "want only discharge any firearms" or. So that the provision would then would make it an offense for the person who, in the streets, lanes, or squares of any town or in any thoroughfare or highway, discharge any firearms or make any bonfire or throw or set any fire to any firework, or who, to the danger and annoyance of any passenger or inhabitant, shall throw or discharge any stone or other missile, or who shall fly any kite or play any game. So those are the amendments to other acts. Memorandum of Objects and Reasons. Yes. With 85% of the murders recorded yearly, a murder rate of 46.5 per 100,000 attributed to a firearm, it appears that the proliferation of firearms in Jamaica is a direct catalyst for the commission of murders. The data indicates that most gun-related crimes are committed using firearms that are outside of the regulated firearms regime, meaning that those firearms that are illicitly trafficked, manufactured, or diverted. Accordingly, it is necessary to establish a framework dealing with firearms that are illicitly trafficked, manufactured, or diverted that A, is distinct from firearms that are duly registered by the Firearm Licensing Authority, and B, targets prohibited weapons, including unregulated firearms, and the activities connected thereto, such as illicit trade, manufacture, stockpiling, possession, and use. In this regard, the proposed framework provides for offenses and penalties that are appropriately dissuasive and commensurate, in respect of prohibited weapons, including mandatory minimum terms of imprisonment for particularly egregious offenses. Additionally, there are a number of operational challenges faced by the authority, the Jamaica Constabulary Force, and the Office of the Director of Public Prosecutions, based on the limitations of the Firearms Act 1976. The current legislative framework is inadequate to meet the obligations under the following international instruments. A, the United Nations Protocol against the illicit manufacturing of and trafficking in firearms, their parts and components, and ammunition, supplementing the United Nations Convention against Transnational Organized Crime, Firearms Protocol or FP, which Jamaica signed on the 13th day of November 2001 and ratified on the 29th day of September 2003. B, the international instrument to enable states to identify and trace in a timely and reliable manner illicit small arms and light weapons, 2005. C, the Inter-American Convention against the illicit manufacturing of and trafficking in firearms, ammunition, explosives, and other related materials, signed on the 14th of November, 1997. D, the United Nations Arms Trade Treaty, signed on 3rd June 2013 and ratified on 3rd June 2014. When compared against Jamaica's obligation under those instruments, the Firearms Act 1976 is inadequate in several areas, including in relation to A, the marking of firearms, B, stockpile management, C, record keeping, D, international transfers and brokering, and E, risk assessment and due diligence activities. This bill therefore seeks to give effect to a decision to repeal the Firearms Act 1976 and to replace it with appropriate legislative provisions in accordance with the proposed framework to A, strengthen penalties for offenses related to prohibited weapons and prohibited activities, B, address operational challenges faced by the responsible authorities under the Firearms Act 1976, C, address new threats caused by advancement in technology, D, better address Jamaica's international obligations, and E, consequentially amend certain other enactments.
Act of 67, 1967. There were amendments in 76, but the Firearms Act of 1967. Yeah, the Firearms Act of 1967. Right. I think this lays out our kind of précis of our policy. This. Thank you, Ms. Grant. Ms. Golding, you're coming on. So, the next phase. We have gone through.
Not hearing you, DPM.
Yes, thank you. Thanks. We have gone through in good time. It's for the clerk to put this together now for us. But tomorrow we are talking to Ms. McCarthy, GRA and Customs.
Yes, sir.
Anybody else?
Not at the moment.
Mr. Champagne, you need to circulate his.
Yes, sir. But I've not received a response from him as yet.
All right, we'll take those two. Maybe we have another stick for another two. Honored Bar Association and the Jamaica Defense Force. The other who have contributed are largely a reflection of much of what in the Jamaica Rifle Association recommendations. So, and one or two a little bit off key, which we don't need to. We can examine it on the matrix put out, but I don't think we need to call many of the others. members may wish to comment after I've had a chance to look at the matrix, but I think if we do it, Rifle Association and the Customs, JDF, and Cornwall Bar Association would have covered all the substantive recommendations. All right. Thank you.
Mr. Chairman,
Senator Sinclair, go ahead.
before we close off, it's a question that I want to just ask. And something was published in one of our national newspapers that indicated that, and they identified 2 prominent persons now deceased, but then there are others within the country that would hear comments about. In relation to number of firearms that may be issued to one person. So you find firearm licenses being issued to one person, they hold 7, 8 firearms, and they are not necessarily that they are in any competition, like persons who are in competition and the firearms are used for that purpose. You find persons holding 4, 5 handgun permits and so forth. What is the position of the policymakers and why should one person be facilitated with 7 firearm permits?
Thank you for raising it, Senator.
I don't know if you have given thought to it, and it may be a curveball, but I don't know if something can be.
No,
we can look at it while we go to the deliberations.
In fact, I want to become aware of it since yesterday. There has been some comment in the media. I haven't seen the report myself, but it seemed to be something we should maybe include in the regulations rather than the law, as we go forward. Because for those who are in sports shooting, the firearms used in sports shooting are very specific. And for those who even get involved in rifle shooting, they're also specific. There are specific firearms with particular, not on the board, but they're built for sports shooting. And you can accommodate those, but to issue in the current situation, 7 firearms, and including 5 handguns to one individual citizen sounds without any special reason, not in keeping with our messaging to control the rather, wild use of firearms. I think we should look at it, and I would urge that the team doing the regulation bring this up, Senator. It will come back to the parliamentarians for discussion. But thanks for bringing it up, because really it's unreasonable for someone to exercise that level of influence on the Firearms Authority and pick up with 7. There's a shotgun on the side, maybe 2, but 5, 6, 7. Sounds like we are going a different route. Any other comments? If not, for those who are on, I want to thank all the members. Yes, we have taken a lot of your time. Senator Bunty was on for a while. Senator Scott Martin, Senator Charles Sinclair.
I'm still on, Mr. Chairman. Still on,
yes,
still on.
For all the senators who have to work for a living in the private sector, that give us all the time. I want to thank you all. That it's not finished, but we have come a long way, and we'll take some time tomorrow to look at the submissions, and I think after that we'll give time to the House clerks to put the recommendations together, and all CPCs give some time to put in to make the amendments to the clause as required. I think we should be able to tie it up in the month of May. There is, as I said, some continued urgency. The men are using firearms now in a very wild way. Everybody's in drive-by shooting and all of that. But we need to get this law right. So commend all the contributors, and we proceed from here with it. It's not say it won't hurt, but if we wait a month to get it right, I think it will be worth the while. I've done a lot of new and creative things here. I'm learning a lot of law. Senator, you're with me. I'm a layman. But we'll adjourn now until tomorrow at 11, I think. when we're taking submissions from the Jamaica Rifle Association and the customs, and that will be hybrid. Yeah. So we'll be online. Okay. Move for the adjournment tomorrow at 11, and tomorrow 11 o'clock tomorrow. And there's a short meeting in the house, I think, before.
So move, Mr. Chairman.
Moved by Senator Sinclair, seconded by Senator Motley. Members, have a good evening.
Same to you, Chair. Thank you too.
Hi, Chair.
The one thing, doing enough work for all of us for the evening. Okay, thanks.
Reduce your risk of